Good morning. Welcome into Clear Path Retirement Radio. As always, I am Stewart Smith here with Mitch Davies.
Good morning.
And we are here today to talk about trust and estate planning for retirees. How you doing today, Mitch?
Doing good, Stuart. I'm excited. This is going to be a good one. This is something we've seen more and more. Trust estate planning has become more and more accessible over the years, and we've got a exciting solution to this thing, and I'm excited to get into this today.
I tell you, what I've noticed over the years is estate planning, it tends to intimidate folks, and they tend to kind of shut down when you start talking about this subject. And what I've learned is it's really not as complicated as we make it.
It's not.
And so we're going to help today. We're going to help give you a little clarity on that, help you understand, when's a trust needed? When is, a will suffice? All of those things that people ask us and wonder about, we're going to try to answer today. And let me just start by saying that some people come into us and they say, hey, I've got a will, so I'm good, right?
All the time.
And that's a very interesting question because always my answer is, well, it just depends on what you're trying to accomplish. If you have your assets, and let's talk about it for a second. If you have your assets, you have investment accounts, you have insurance policies, you have annuities, you have those sort of things, and you've named a beneficiary on those accounts, then, those things are going to bypass probate as a true beneficiary designation. And so you really don't have to worry about those things unless you don't want all of those assets passing to the beneficiary all at one time.
Right.
And that is something that we hear more and more of nowadays where people don't want that. I had someone in the office the other day and they said, listen, I don't mind if two of my kids get the money all at once, but that third kid, heck no. Right. I tell you what, he will go through it like a drunken sailor. So I want to make sure that we stagger that and give him so much every year or every few years, and that can't be accomplished with a will.
It can't. And this is people hear this kind of planning and hear this kind of, idea and get, again, intimidated. People think a trust fund, right? I remember hearing the term, before I got into this business, I'd hear the term a trust fund and assume it was this huge, complex legal thing to set up. But, we can accomplish that sort of planning for people at a super low cost, super easy. It doesn't take very long. And it's something that's much more accessible than you might think to accomplish that level of planning. And we'll kind of get into that today, but it's been exciting.
Yeah. So, back to the will, listen, a will is fine for, if you don't mind stuff being probated. And that stuff that we just mentioned, the bank accounts, if you've named a TOD or POD, and that's a transfer on death or paid on death on those type of accounts, then those will bypass probate as well. Again, all being dispersed at one time. So, that's, if you're good with that, then the stuff you got to worry about and the stuff that we talk about the most is real property. And what I mean by real property is typically real estate, things that, are going to get caught up in probate typically. And, how do I handle that stuff? And a lot of times a couple will be sitting with us and they will say, hey, we've got our home titled Joints with Rights of Survivorship. And what that means here in South Carolina is that, it's joint with rights of survivorship, meaning it's jointly owned by that couple. And if one of them passes away, all the ownership transfers automatically to the living spouse. And that's great. That's awesome. And so most people think that's as far as they need to go.
Right.
And they will, say, we're good, right? And I'll say, yeah, you're good until the second spouse passes away. And then what happens, right? Like, then what do you want to happen to the house? Do you want the kids that are going to inherit it? Do you want them to have to go through probate? Because if you don't mind them going through probate, then yeah, I guess you're good.
Right.
But, you know, most people, they don't want to go through probate. And if you've ever gone through probate, and I ask this question a lot in workshops, it's not a party.
It's not.
Right? It's no fun. Probate is a hassle. It costs money. It takes time. It ties assets up. And so, you know, if you have a will, the will is the probate document. It is what gets probated. It is what the probate judge uses to determine how to distribute your assets. But it does not avoid probate, which, you know, a lot of folks, that is their sole intention, is I don't want this stuff to go through probate. You know, some reasons that we hear constantly on that is, first of all, probate costs money. And, you know, I gave a great example in a workshop that I did yesterday of, you know, listen, if you own a $100,000 home, a home worth $100,000, the typical probate cost on a $100,000 home or a $100,000 estate, as we would say, is 3 to 7%. So at the lowest end of that, you're looking at probably about a $3,000 bill to probate that home, which, let's face it, a $100,000 home nowadays is not much, right? I mean, most homes average in the, you know, $300,000 to $400,000 range here. So, you know, I would say that, you know, to be able to avoid that, to be able to avoid not only that $3,000 fee, but also the hassle of going to probate and filing the paperwork and waiting for that to get in front of a judge to be, you know, finalized and dismissed, having creditors be able to come at you and say they owe you money, or, you know, putting that out into the public as public knowledge, which what probate is, and a lot of people don't understand that, you know, probate is public matter, and you leave assets to the next generation through the probate process, you're giving everybody access to that information. So a lot of people want to avoid this whole mess of, you know, having to go through the probate court, having to wait, having to be, you know, subject to creditors, having, you know, all of that be public knowledge. And, you know, for folks that come to us and want to just create a trust, and what we create typically, you know, 99% of the time for folks is something called a living revocable trust. Let me say that again, a living revocable trust. And what that does is it creates kind of a funnel, so to speak, for your assets. And anything that you fund that trust with, once it's established, anything that you retitle into that trust, which is a little bit of a step, but not really. I mean, it's not that difficult. A real estate attorney or title company can handle it. It's a few $100s typically to get your home retitled. But to get something retitled into that trust, now it funnels into the trust and is distributed according to whatever specifications you put in the trust, and bypasses probate completely. And it's a private matter, right? And creditors can't come after it. Predators can't come after it. The whole 9 yards, you know, where it's, you know, it's just so much easier. And we do those every day for our clients in our office, where they don't have to leave our office. It is a attorney-driven process, because we've partnered with several local attorneys in South and North Carolina that have partnered with us on this, and we are able to bring them into the fold virtually and build out the trust, do everything, notarize it, witness it, make sure the language is bulletproof, make sure it accomplishes everything you need to accomplish. And we do that. If you have no other business with us, you can come in and do that for $1,400.
Yep.
That is $1,400 up front to avoid the hassle, the time, the public display of what's going on, all of that on what would cost you maybe $3, $4, $6, $8,000 to get through probate. So it just, at this day and age, it doesn't make sense for you to go let your assets go through probate when we can do a living revocable trust for you at such a fair price that it doesn't make sense to have this stuff in a will anymore.
There's no reason not to. The couple steps it's going to take us to establish the trust and get things titled in the trust and get everything into that funnel. If you've never dealt with, probate and a probate judge and a probate court, there's 10 steps. I mean, you're going back to that court multiple times. We see it all the time, right? You have to go back, and then you have to get the attorney. You have to get the letters testamentary. Maybe people don't know how to do this. It's complicated. There's a lot of different steps. So we take a couple hours to get this trust established, get everything titled in it, and your life and the next generation's life is infinitely easier.
If this is something that appeals to you and you've thought about it, but you're just not sure how to take that next step, come to clearpathretirement.com. Let us know that this is in your thoughts, and let's set up a time to sit down and talk. We'll be right back to talk a lot more about this.